Yes, good evening to the students of the SLW 600, 616, 646 and 670, and this is the model for each and everybody. And please karibu sana to my class, welcome to my class. And I posted on the screen something. Could you read it by unmuting your microphone? Anyone? Quick.
It's too small.
It is too small. Now it is not too small.
How to make an error for law school.
If I say read, nobody will read. And when you read in the chorus. Immediately one can. If one is reading, another please keep quiet. Who is reading? Anyone?
How to make an Iraqi for law school.
I wrote welcome to the students and so on and so forth, and you forgotten it. Okay, doesn't matter. Either you read it or forget it. Yes, now this is the work of this B. Hawa. Already we discussed this thing again, and I made the correction, but I don't know whether she has sent the same thing or not. Better you can go to the other thing where he committed mistakes. I think here, yes, this is about the roster work, and we discussed here up to the certain extent, but again we did not see the what it's. I believe that we discussed it because roster has made only applications. He wrote the cases there. No, that is not the style of writing. You take the issue and say in the so-and-so case law it is decided that and that would be very much useful, and you give the explanation for that one, not the just number of the cases you have to mention there. And who passing the street amount to the condition, that will purely the solicitation of the public places and give the cases. No. For each case law that you have to say that this case law shows that either you stand on the balcony or you stand on the road, but it conveys the same thing, because that is the intention of the parliament, not to lure the customers, those who are going on the street. That is their intention. So you can stand on the road, or you can stand on your balcony or in your door or in your dirisha window. It doesn't make any difference. Then each issue that you have to take it and you have to support the cases in that way that you have to write it. But when I say what is reflected in the rule should be reflected in the application. Yes, reflected in the application, but not in the way of the cases. Cases with its explanation. And that is more important factor. So this is not the style. And the second issue, whether the defendant was properly punished under the aims of the acts to clean up the streets, to allow the people to work. Whatever the second issue, supported case law, it is given in the original case, that should come over there. And it is observed in the so-and-so case law that the intention of the parliament is to not to lure the customers for the prostitution. That is the way you have to make it out. And the conclusions are concerned. The court concluded that the defendant was soliciting men who passing the street by attracting them for the prostitution purpose. This even by the being the premises, but the acts of the attracting and claim calling men in the premises that will amount to the conducting the prostitution business and public place. Okay, you can write it no matter, because the idea is the same. And the second issue is the law's event. Never write the contraction in your body of the writing. The law is don't. No, this is a contraction. The contraction should not be written. It should be right the total. The law do not cover those who conduct the prostitution. Can you say the conduct the prostitution? Is it a marriage? To conduct the marriage? That who conduct the prostitution. Can we say the conduct the prostitution? We can say who make the business of the prostitution. There is a business, one way in another way. There is a commercial transactions. Are you following me? Say yes.
Yes.
It
Yes.
is not a ceremony. It is not a ceremony to conduct. It is not an occasion to conduct. Is it clear?
Yes.
Yeah, the activities of soliciting, there is a soliciting that there were in their premises, there is something grammar spelling is there. The premises, but the laws intended to, okay, this Karsaski is coming down, now I can close it, okay. The laws even don't cover those who conducted the business, no, make the transaction of the business, transaction of the prostitution activities by soliciting, there were in their premises that the law intended to stop the business. Yes, the protecting the, see here the business wrote. See, the actuality is the business. The protecting the man who passing the streets, and therefore the defendant was properly punished. Yes, the defendant was punished, and that is a quite good disposition. The two issues and two conclusions and two paragraph the application, but the cases should go together. And they have to give the answer in that manner, not merely citation of the cases. So that is the thing which I found. Then let us see that who wrote the other thing, but I received only these are things. Wendy Nama, but she did not make it. Rosta Smith, I wrote another one also. The brief case briefing where the roster and Donegal versus Stevenson. Yeah, this is the original case law, but 5 students how to write Iraq. Where is the Donegal? Another Donegal. These names, no, model. Yeah, Nuru. Let me see what is the Nuru work. Yeah, Nuru also wrote the procedure Donegal versus Stevenson. Can anyone tell me what is the mistake here committed? Nuru? Nuru, are you present? I did not see that Nuru name.
Yes,
Rosa
Professor,
Mafuga
I'm
is
here.
present. Nuru Mambuli, yeah, I could see you, yeah. Mishimiwa 576162346. Please ask Rosta or Bibiliana Kilio or Damina Monica or Fortunate Guvetta how to enter into my login in my online class. Don't enter with my meeting number. Are you hearing me? 176162346. Say yes. Unmute and say yes. Neither he is saying yes nor saying no, not saying anything. I don't know whether he is present or not. Or he is a kamata. Huh? Please don't tell. Otherwise, no, I can make you to lobby out. I can send you out, expel you. Speak. If you don't speak, I will expel you. 576162346 who joined in my online class. Unmute and speak. Yes. Next time now he will come with joining it. Okay. Now let us come to the point here. Yes, what is the mistake committed here? Immediately. Sema.
Citation.
Keep your gadget near to your mouth and speak. Sio paka kama simba kike adume.
No citation, Professor.
Speak.
It was committed on the citation.
After we, there is no full stop number 1. Then the continuation is comma and citation will follow. And I told you, don't keep the AC, the old style. It is initialism. No, I will not. I will not in you till you change your style, because I told you several times. So AC 562, comma UKHL, and here you cannot make it anything because this is also initialism. Okay, 100. Then there is no any punctuation after 100. Yeah, that is the style I told you. Okay, Lord Buckner. Okay, this is okay. These are the quorum. The judges present over there. This is an appeal against the interlocutory of the second division of the Court of Sessions. Very good. And Lord Munsif, the second division of the immunity. Why you are saying the second division, first division, third division, so and so? Just to say it's an appeal case. And recall the interlocutory. Again, you are saying the same. No. Say whether it is an appeal case or not, just to say that it is an appeal case to this court. Then what is the contention? Number one, a manufacturer is held liable to pay the damages to the consumer. That is the contention of the consumer. What is the defense? The defendant say that we have taken a lot of care and hence we are not held liable. Then what is the court decision? The court decision is there. Even though there is no privity of a contract, but the consumer is your neighbor and he was suffered and the seal is not tampered, hence is the negligence in the part of the manufacturer is liable. Just you can write the one sentence. Manufacturer is held liable in this case law. First, contention of the plaintiff. Second, defense of the plaintiff. Third, disposition of the court. How many points are there in the four? In the crux of the procedure. Number one, whether it is the original case law or the appeal case law. Number two, what is the contention of the plaintiff? Number three, sentence. What is the defense of the defendant? Number four, the last one. Last sentence. Sema. Unmute and say.
Disposition.
Disposition of the case law. What is adjudicated in the case law? What the case is decided here? Whether case is dismissed, liable is there, not liable is there, and that thing should come over there. Is it clear? The person who sent it, are you hearing me? Say yes.
Yes, Professor, yes.
Very good. Good. Nuru Wambuli. Okay, now the next point is facts. On August 26, 1928, Mr. Donegal, plaintiff friend, purchased a drink. Can the time is an important factor here? Whether time is an important factor here?
No.
No, because it's not a contract where the time is very much important. Here we can eliminate it. No, there's a plaintiff purchased and drank a bottle of the ginger beer which was manufactured by the respondent. Very good. Stevenson, very nice. Donegal poured some of the ginger beer into her glass. Somewhere will glass say, somewhere is a tumbler. Is it a glass or a tumbler? Mambuli. Is it a glass or a tumbler? Speak. Sir, I don't know. At least say, I don't know. Say, I don't know. Unmute and say, I don't know. Are you present, Mambuli? I could not see her microphone. Okay, I could not see her microphone. Okay, come on. And she drank, okay, no matter. and found decomposing snail is there. Okay, she drank some before her friend poured the remainder of the drink into her glass and found the decomposing snail. Mrs. Donegal suffered a shock and severe gastroenteritis. Okay, the appellant argued that the ginger beer was manufactured by the respondent and thus he had a duty to enforce the system to prevent the snails. Okay, it was held his duty to provide the efficient system of inspecting the bottle prior to use it. There is a quality control is there before any product comes out. The quality control will certify it. The respondent did not believe that he owed such a duty to the appellant, and so the case is in this court for the disposal. Vambuli, you have to write the cases for the disposal for this fight between the tussle between the consumer and the manufacturer. Okay, now the issues are concerned, right, whether or not the Stevenson owed a Donegal a duty of care in the absence of the contractual relation between them. Very good. I appreciate, very good. But where is the full stop after them? Them after there is a full stop. Okay, rule. Yes, what is the mistake that you have committed here? Vambuli. Vambuli is not present. Anyone can say. What is the mistake committed there in the rule? Please speak. I will die. If you don't speak, I will suffocate it. Yes?
The first one was supposed to be in italic, Professor.
Number one, you did not make the case law in italics. Number one. Number two,
The name of the pretender was supposed, the first letter was supposed to be in capital.
then next. Next.
There is no full stop after V.
No full stop after the V. Small v. Next. Fundamental mistake that you have committed. Here. You are not supposed to keep the round brackets or circular brackets because the Kuhn's-Benz division published in the volumes, when the volumes are there, the year should be square bracket. Umepata? Sema dio. Umepata? Sema dio.
Dio.
Yes, if you don't say like that, I tell you the three stanzas, you know it. My hands are handcuffed, my tongue is tied, my legs are fettered, I cannot move further. So this is the style of square bracket 1883, 11 the volume QBD and 503 the page, and the same mistake that again you have committed here. There is no full stop after the V, but it is in italics, very good, but always the continuation of the citation should be there, comma. In the exam, of course, it is a take home, you wrote the citation. In the exam, you need not to write the citation. Are you following me? Say yes.
Yes, Professor.
Good, good. See, when I say you have to give the reply so that I think that you are with me and I am with you. Both are sailing the same boat to reach to the Unguja. Najua Unguja. Say my yes. Dio.
Yes.
Okay, again the same. Dominion, natural gas. The same thing. And italics. And then it should be end with the comma. And where is the full citation? Hakuna amna. Sema nimekosa. Yeah, when you write it, the take-home examination, hence you can do it the citation, but the examination you need not to write the citation, but you have to write only the cases which are there in the original case law. And if there is any other, I don't know why you did not mention that A neighborhood principles also there here in this case law. And the privity of contract is a fallacy also there in this case law. Yes, you check it in the original case law, it is there or not. If it is there, you can make it out. If it is not there, you don't put it over there. And the application is intended for the consumption of the members of the public under the duty to take care of the manufacture of these articles. The finding of the two recent cases that which have considered the Donegal versus Stevenson. Of course, this is the original case law. You need not to write it again, the Donegal versus Stevenson. It's the original case law. But when you give the problem question, yes, you can say the problem question, the facts are given is nothing but the facts of the Donegal versus Stevenson case law. When problem question is given, the facts which are given in the examination paper is nothing but the facts of the Donegal versus Stevenson case law. That is the exact case law. You can write it. But here I am giving the judgment, the total case law. Then you need not to write again here the Donegal versus Stevenson. But you can write the Heaven versus Ponder. Yes, Heaven versus Ponder, that it's clearly mentioned. Even the George versus Stevenson. Oh, you made all the things at one place. Write one line of the principle and you decided in this case law. Again, you write the principle and decided in the case law. And you write the principle and decided in this case law. All the above three case law will say that the manufacturer will be held liable to pay because the consumer is the person who is the lost, and though he is not a party to the contract, but still, and he will not be held liable under the contract, under the privity of the contract, but still under the tort he will be liable because element of the negligence is there. Element of negligence was there, that you have to say in that way. So that will be a quite good idea. But don't write all the things at one place. Write one sentence and the case law. Write another principle and a case law. Write another principle, what is held, and write. So all the three cases also consolidate our cause of action for the manufacturer is held liable even though there is no contract between the consumer and the manufacturer. And here the privity of contract is a fallacy also proved over there. But there is a Winterbottom case law is there, I know. Winterbottom case law, you did not say it. And it is there in the original case law, I know it. Because the Winterbottom case law is there, which shows that a party to the contract can only sue. Means a privity of contract will be there, then the party can sue. So Winterbottom case law is overruled here because even though he is not a party to the contract, but still he would be liable because he suffered the damage, though not in the contract, it is in the tort, under the negligence. Is it clear?
Yes.
Yes.
Yes,
And generally the competitive examination that I will teach them the law of tort, then I will say, which is the element, mostly the cases revolved around in the law of tort. Number 1, defamation. Number 2, malicious prosecution. Number 3, public nuisance. Number 4, negligence. Which one is the appropriate multiple choice? Did you understand my question first? Say no.
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 Multiple choice questions. Najwa, multiple choice questions.
Yes.
There are
Yes,
4
we know.
choices are there. Among the 4 choices, you have to select one choice which is very appropriate. So my question is, in the law of tort, the most of the cases dash. Number 1, defamation. 2, public nuisance. C, malicious prosecution. D, means 4th, negligence. Which will you take it? Which will you take it? A, B, C, D. A, defamation. B, public nuisance. C, malicious prosecution. D, negligence.
Negligence.
Negligence is the species. No, negligence is the genus and all other things are species. Najwa, what is meant by genus?
No, Professor.
No.
Big area. Like Tanzania is a genus. And Monza is species, means part of the Tanzania. So how many species are there in Tanzania in genus? Mbeya, Arusha, Tanga, Iringa. Are you following me? So these are all the species.
Yes.
Yes.
Genus is the here one. Like reptiles. In the reptiles is a genus. The species are fish comes under the reptiles. Crocodiles comes under the reptiles. Snakes comes under the reptiles. Are you following me?
Yes.
Yes,
Yes.
Professor.
So that is the genus and this is the species. So negligence is the genus and the species are defamation, malicious prosecution, public nuisance. In everywhere the genus is there, means negligence is there. So when you terms in the term of the philosophy of law, it's a genus. Jurisprudence is a genus. And all other things, natural school and philosophical school, analytical school, all the schools are the species. Because it says about the philosophy of law, that is the jurisprudence. So is it clear now? Now let us come to the point again. That is the way that you have to make it out. Proximity of the cause is there, neighborhood is there, and situation could not in which the court considers fair. And when you say the proximity cause, and actually you have to represent here in the rules. There is no proximity cause. It's a fallacy, and neighborhood principle is made over there in this case law. And there's the same thing that you have to narrate in the application. And one more point also there. To my knowledge, if you see the case law, that is called novus actus intravenous. Novus actus intravenous means no breaking of the chain. Even that also be there. Of course, if it is there in the case law, you can mention it. If they are not there in case law, you need. But to my knowledge, it is there. Because there is no break of the chain. Here the break of the chain means from the manufacturer till it comes to the consumer, the sealed bottle is there. Nobody tampered it and inserted the rotten snail in it. And that is also another point. But anyway, it doesn't matter because whatever that may be there, you have to cite it and that will be quite good. What is the spelling of the conclusion? Bamburi, are you present? What is the conclusion spelling? And what you wrote? Is it visible? Say yes.
Yes, it is visible.
Yes, right. You spell it. Spell it. Spell it means read the spelling.
CONCLUTION.
What should be the right one?
CONCULSION.
Did I change it?
Yes, Professor.
Yes. So the rule that you are love your neighbor, okay, in law, and because your neighbor is the last person, and your neighbor, this thing should be correlated with the issue. Only one issue is here. How many conclusions you wrote? Conclusion? You write only one line, one paragraph. Because you did not discuss there the neighborhood's rule. If you discuss the neighborhood rule, yes, you can conclusion you can make it here. And at that instance, you did not mention, that means try to avoid it. But generally, when you mention it in their neighborhood principle in the original case law, definitely you have to put in the issues. Whether there is a neighborhood principle is followed or not, number one. First, manufacturer liability, number 1. Number 2, neighborhood principle. Number 3, novus actus intervenens. No new character entered and broken the chain. Yes, that also you can say, because it is there in the original case law. So therefore, if you make it the 3 issues, yes, you make the 3 different. Number 1, manufacturer liability there. Number 2, neighborhood principles are there. Number 3, there is no break of the chain. And you can also make the privity of contract is a fallacy also. It is one of the issue. Yes, 4, you can make it in the conclusion 4th. Privity of a contract is a fallacy because that is dealt in the Winterbottom case law. But the Winterbottom case law is overruled in the Donegal versus Stevenson case law. So when you read the case law, at least 2 or 3 times, you will understand what should be written and what should not be written, and which are the relevant things, which are not relevant things. But cases, maxims, principles, doctrines, definitely it will come under the rules. And you can also frame the issues depending upon the rules. So that way that you have to write it. And if you don't agree suppose if you don't agree with the decision, then I told you the side heading, my opinion. Side heading you can write my opinion, and you can also say, yes, the land court has committed a mistake in the so-and-so place. Because you have every right to say. Because there is a ground to say. So that way that you can make it out, your own opinion. Sir, writing this thing is only the greatest thing, then how could I write my own opinion, sir? Okay, don't write. But I am showing you, an intellectual man, and who is writing, he can express his own ideas, and he can disagree with the court decision also. So that's why we can say there is a dissenting judgment, there is a assenting judgment. Am I right?
Yes, Professor.
I appreciate. When I ask such a thing, you have to give the answer. That is my intention. Otherwise, if you don't give the answer, I told you the 3 stanzas. Number 1, my tongue is tied. Number 2, my hands are handcuffed. Number 3, my legs are fettered. So these are the things. I would like to see the Rosta, another work he has sent, the same, Donegal versus Stevenson, he sent it to me. Whenever you send your file, I told you, to me, Akili. How could you write it that way? See, Rosta, see, his work I am showing you. The one is Mafuga Rosta. And he wrote in the Mafuga Rosta. I don't know whether I made it in the Mafuga Rosta M. Yes, it is there, Mafuga Rosta. In the Mafuga Rosta, you tell me which is the forename, which is the surname. Rosta, are you present? Keep your gadget near to your mouth and say. Rosta is a surname or Rosta is a forename? See, your voice is not visible to me, audible to me. So now I will tell you that what is, how you should have to write it. Because that is the style of writing. What I want to say is, the style of writing is, here I am showing you. A new. Yes. For instance, the style of writing I will tell you. See, my name is, what is my name? Sema. What is my name? Unmute and say. Participants, are you sleeping? Are you hearing me? My voice is
Mohammed
reaching to you.
Hussain Saheb.
But why you are taking so much time? See, here I am writing Mohammed Saheb Hussain. That is my name. Now you tell me. Yes, I made the bold also. Now you tell me, which is the forename, which is the surname, which is the middle name? Unmute and say.
Muhammad is the first name, Saheb is the second name, and surname is Hussain.
I did not use the word what you used it. I said, what is the forename, what is the middle name, what is the surname? These are my wordings. But you say first name, you say the second name, you say the last name. I did not say like that. Now you say. Say. Anyone?
Muhammad is
the
a
first
full
name. Saheb is the middle name. Hussain is the surname.
That is the style. Surname is the Hussain. And the middle name is the Saheb. And the forename is the Muhammad. So when you are writing in the citations, not citation, referencing, what should have to come first? You take any style, Arabian style, Chicago style, Harvard style, or APA style, that is the Anglo-Psychological Association style, which the South is following. What should come first? If you don't know, say pass on. Don't kill my time.
surname.
Surname comes first. And in the APA style, you write surname in this fashion. Surname should be written in the capital bold. In the APA style, Anglo-Psychological Association referencing style, where the South is following. Next, how do you write? Next. Say next. Say pass on. Don't kill my time.
Middle name.
That is not the style of making. Wrong, Kosa. The forename initial should be there, full stop. The middle name initial should be there, full stop. If it is a continuation, you can keep the comma, but the APA style doesn't have the full continuation. And later on, it comes the style, year comes, say about 2013 year. Next, if it is single author, you have to write in this style. Double author, you have to write in the different style. Okay, time being, this much is enough for you. I don't know whether you know the referencing or not. Najwa referencing, you should not supposed to know it because you studied in the legal method. Is it clear?
Yes, Professor.
Good. So that is the style of writing. You have to make it out, and we are discussing whose work? Yes, here. This we already, I think we discussed already. Oh, this is our rosta work. Rosta Karibusana. What is the mistake committed, rosta here, Sema? What is the mistake you have committed? Anyone? There is a mistake committed here. What is that mistake?
Citation of names.
Kosa. There is a mistake is there if you closely observe. Say Pasan.
Person.
There is no full stop. Did I keep the full stop in my model? Did I keep the full stop in my model? I have already shown you.
No.
Then why did you keep the full stop there? Same anime cosa. Yes. Then Lord Atkin, Lord Tharkan, Lord Bagmixer, well and good. This was an appeal from the Supreme Court to the House of Lords. Very nice. Whereby the consumer sued the manufacturer. What is that manufacturer? What is this manufacturer? Sema, nime kosa.
The first one.
Manufacture of the ginger beer for the negligence resulted, okay, from ill caused to, ill caused to, can you say ill caused to? Can you use the word ill caused to? Illness. The resulted, actually resulting the illness, resulting from the illness caused to her due to the drink of the ginger beer that contains the remnants of, not remains, remnants we can say, REMNANTS, remnants of decomposed, yes we can say decomposed snail. Yes, what is the synonym for the decomposed snail? What is the synonym for the decomposed?
Rotten.
Rotten. Another synonym? See, here I am writing. I am writing with the virgule. Rotten. You can say. Another is putrid. In some of the books you can say decomposed, some books rotten, some books you can find a putrid snail. Of course, when you say putrid means dead snail only. So the manufacturer pleaded that he has no contractual relationship with the consumer. The appeal was dismissed. Good. Appreciate. Issue number 1. Nini kosa haba. There is some kosa vote.
Question mark.
There is no question marks in the issue. Always ends with the semicolon and ends with the semicolon and the last one ends with the and, then it would be the full stop. That is the style of writing. Is it clear?
Yes.
Contractual.
Yes, Professor.
What is the spelling of absence of a contractual? We cannot say on. Manufacture in absence of. In should be used. And here not for used. Was entitled to a compensation. Not a compensation. Because compensation is abstract noun. The abstract noun doesn't have the a. Is it clear?
Yes.
Yes, Professor.
Professor.
Yes. If you miss my class, you miss many things, including the grammar. So now the fact the consumer went to the cafe with his friend who bought the bottle of ginger beer, which was an opaque spelling, an opaque. An opaque, because oval. And that's the drinking. Then she drank the ginger beer by using a glass of, a glass, and the continuation of the drinking, she poured the ginger beer to the glass. Actually, she did not pour the ginger beer. He poured the ginger beer in the glass and found the remains of the decomposed, the fancy. Anyway, the consumer found ill and found ill. The consumer was found ill and suffered from. It is not suffered from. Okay. Further, she was in ginger beer and so manufacturer. Therefore, comma should there. And manufacturer, no, manufacturer. And with the manufacturer, what is that they say? With the manufacturer, because she was not the one who bought the ginger beer. Okay. Anyway, the facts you wrote very nicely. It is from. Okay, we don't see your grammar. At least the idea is there or not. We will see it. But you have to write in the fact this. Hence, the case is now in the House of Lords for the adjudication. Where is that? You did not write there. Where is the house now adjudication? The last sentence should say that, hence the case is now the House of Lords for the adjudication whether the manufacturer is held liable or not. Or you can say whether the case is at the adjudication of the House of Lords for the decision. Tosha. Rule. Only one rule is there. There are many. Winterbottom is there, and Heavenly One's Pender is there. There are many other cases are mentioned over there. Why did you mention only 2 cases here? Of course, that to be no full citation. And you have to write the cases in always in italics, and the verses is full stop, and continuation is a comma. Then the here 1817, because it is an all-England report, or Queen's Bench or King's Bench, which is having the values. Next the page number comes, and no punctuation at the end. And Mullen versus AG Bar and Company Limited. What is the mistake it is committed here? Number 1, italics. Number 2, V after full stop. Is what is the mistake here? What is the mistake here? Say pass on. Argue with the answer.
Pass on.
CO. What type of the abbreviation it is? I told you the 4 type of the abbreviations to you. Number 1, initialism. Number 2, acronym. Number 3, shortening. Number 4, contraction. The CO stands where? Don't kill my time. Say pass on.
Pass on.
CO is shortening. In shortening, first letter should be the capital letter and the next letter should be the small letter and ends with the
Full stop.
Full stop.
What is the synonym for the full stop?
The dot.
Period. Limited. It is also the shortening form, and hence because L is the capital letter, TD is the small letter, and hence full stop, and the continuation should be there, comma, then the citation should have to come over here, that is the square bracket, and these are the things that you have to be supposed to write it. In the examination, you need not to write it because it is your handwriting examination, not the computer-based examination. And you have to cite the many other cases. You cited only the 2 cases. Sioto, Shah. Whatever the cases should be there, and whatever the doctrine should be there. What like the doctrine I told you, novus actus intravenous. Number 1. Number 2, doctrine of privity of contract is a fallacy. Number 3, neighborhood principles. Yes. These are all the things should have to come over here. Of course, he wrote only the few things. Did I ask you to make a bullet here, bold? Even italics itself is enough. Then why did you make the bold? Italics itself will give the sense that it is a case law. And when you say Mrs., it is a shortening form. And hence, M capital letter or a small letter ends with a full stop. Because it is a shortening form under the abbreviations. Yes, here also the V, you have to write like this and you need not to make the bold because it is already 1 is enough because you already made the italics, that is more than enough. Yes, only 2 cases you made it. Coming to the 3rd issue is concerned, okay, Mullen case rather you made it, but you are supposed to mention those cases which is already there in the, at least one line you can write. Having the similar nature of the principle is there, at that instance, you can combine together in the both the cases, the principle laid is the same, then you can cite the cases. Because the thing which is reflected under the rules should have to reflected under the application. Okay, now how many conclusions that you make it out? Okay, if the four issues are there, 4 paragraphs of the conclusions. If the 2, because I know that you made the only 2, if I not be mistaken. Let me check it how many. Okay, you made the 3. Okay, now here that's why you said here you made the three conclusions, mean three paragraph conclusions. The negligence which occurs the ill and suffering from the consumers. There is something wrong. Consumers will exclude. See, when you write will is a future tense, at that time verb does not have the s. Verb have the s at that instance only when the subject is a third person singular. Are you following me?
Yes, Professor.
What is the grammar spelling? What is the grammar spelling? Sema.
GRAMMAR.
I appreciate, Winnie Lema. I appreciate. So a clap to the Winnie Lema. Is a clapping there? Yes, manufacturer, but he will be entitled for the compensation. Okay, good. The duty of care to the neighbors were very important on manufacturing.